Well, good morning, everyone, and happy Monday. Just wanted to thank you all for joining us today on your busy work week. And I just want to introduce myself. My name is Lee Leppert. I'm the Senior Creative Manager here at the Cromeans Law Firm. And just wanted to go over a couple things before we start. We will be having a Q&A towards the end of the presentation. This is going to give you an opportunity to talk to Jessica Mora about all of your questions that you might have in regards to filing a mechanics lien. And subcontractors, suppliers, property owners, and other vendors will encounter all kinds of lien-related questions. There are so many deadlines, and the process is quite tedious on what you need to follow in regards to filing. And we're excited to announce that our lien webinar is now an all-inclusive training that includes retainage, residential, commercial, public works, everything that you need to know in regards to filing a mechanics lien. And today we have our lien specialist, Jessica Mora. She will be joining us in just a moment to go through the presentation with you all. And I'm just going to ask that everyone stays muted during the presentation. And then after we have the presentation, I'll open up and send us messages in the chat. You can also unmute yourself and ask Jessica any questions that you have in regards to liens. So without further ado, I'm going to let Jessica take it away.
Good morning, everyone. My name is Jessica Mora. I've been with the Cromeans Law Firm for a little under 10 years. I've been doing liens for about 9. So let's start with the introduction. Why liens are so important. The construction industry revolves strictly on credit. This is the reason why mechanics liens are so important, and it's kind of to protect your money and the work that you've done. Liens are the way to secure credit on a construction project. Liens are filed in the real county property records, and they're against the property owners, even when the owner of the property did not hire you. Because the owner may never know who and had no contact with the claimant, the laws require very specific steps to having a valid lien. By following the specific steps, the owner will have to pay out even when they don't agree. If a claimant misses even one step or a sentence is off in the lien or in the notice, the entire lien can be invalid. So we're going to kind of go over these steps today. So who can file lien? Anyone who provides labor, material for the construction or repair of a house, a building, improvements to a property are entitled to liens. So we'll start by going into the homestead. A homestead is a residence that is owned in the state of Texas. It's your personal home. So if you look at the example on the screen, you'll see where the mailing address has 1 and the property address is the same thing. If you look where the exemption part is, it does say residential homestead. The class code that the CAD gives this one is residential, single family. The protection means you can't have a lien against a property unless there's a contract filed of record. So for me to have a lien against a homestead that I did work on, my contract has to be signed by the owners, whether it's husband and wife. They both have to sign it. It has to be notarized. It has to be filed in the real property records for me to be able to have a lien on their homestead. If an individual does not currently have a homestead and is building a new residence, which is intended to be their homestead, that is considered a homestead. So for example, I live at a townhome or I'm renting somebody else's property and I am building a home. That is going to be my house. That is my intention to make that my homestead. Therefore, that would fall under a homestead. And unless there's a contract filed of record, you have no lien rights on that home. Residential. So residential can include improvement homes, vacation homes, rental properties owned by an entity if they're owned by a company, they do not fall under homesteads. If an individual and his or her spouse are only entitled to one homestead at a time, even if the property is in a different county. So if you see this one here has the mailing address and the property address are two different ones. Yes, it's classified as a residential, but there is no exemption on it. Why? Because their homestead would be at the first property and not the second. If I'm building another home while living in my homestead, I can't claim the other property in my homestead until I actually move into that house. So that would not count as a homestead. Timelines on residential jobs are pretty steep. So months of activity, it's when you did the work and you're owed money. So if I did work January and February, but let's say I was paid for January, my notices start for my time frame for February. So it would, my first notice to the owner and the general contractor would have to be sent out by April 15th. April 15th is the deadline, guys. Doesn't matter if it's a weekend or a holiday, it has to be sent out by the 15th. If May comes around and I'm still not paid, my lien has got to be filed in the real property records by the 15th of May. So those are the timelines for a residential job. Commercial jobs, spec houses. Spec houses are not residential. Spec houses are kind of your builders, D.R. Horton, David Weekley. Those are intended to sell, so those would fall under a commercial job. If you see this one's classified commercial, real property, oh, it's commercial, sorry, non-exemption, it's because commercial jobs are lienable. Warehouses, shopping centers, private schools, etc. Most commercial construction projects have the following tiers. It has an owner, general contractors, subcontractors, suppliers. So all of you guys have lien rights on it. You just have to make sure you followed your timelines on them. Again, the commercial tiers, the owner, the prime contract is between the general contractor and the owner. So the owner will usually not know who the other tiers are. That is why your notices are so important. The GC has a contract with a sub, so they will not know who your suppliers are. The subcontractor, the agreement is with the GC, so they will not know who the owner is. The supplier has an agreement with the sub, so they will not know who the GC or the owners are. No one knows who anyone are unless you ask or do some type of research on it. The supplier should always ask their customer, subs should always ask the general contractor, the GC should ask their subs who their suppliers are. Doesn't hurt to ask the question. Your timelines on commercial, you have a little bit more time. Your first notice is kind of giving it just to the general contractor to let them know, hey, I'm here. If you're a supplier, it's pretty much saying I am supplying material to your subcontractor who's doing work on your job. Please know that I'm here and I'm owed money. Those notices will tie up their funds. So if they're going to get paid within the next week or so and you send out that notice, they're supposed to hold that check. First notice, again, to the general contractor. Second notice, you'll notify the owner and the general contractor saying, I am not paid, I'm out here, this is what I'm owed. Month of activity, it goes off of when you did the work and you're owed money. Not the beginning, not the end. You can work for 6 months at a time and be paid. If you haven't, you still have to send out your notices. Again, January, February, March, I didn't get paid for April's work. So my first notice goes out June 15th. My second notice, July 15th. My lien has to be filed by August 15th. These can get a little tricky because you do not have to file your lien until the end. But if you continue to send your notices out, you're still timely.
I'll find the email.
Public Works. Public Works are fire station, police station, schools. Anything owned by the city or the county are considered exempt, and they're public works. Because the city and the county own the public works jobs, they're exempt from liens. You can't file lien on these jobs, but they do have what's called a payment and performance bond. So in this case, you would file a claim on the insurance on the bond, and it's usually going to be the general contractor's bond or a subcontractor bond, which personally we don't like subcontractor bond, but they're there. So timelines on the public works is it's actually a little shorter. We have that timeline that's non-residential. So I think we have the wrong one on there. I'm sorry, guys, but it will fall under similar to the commercial one. Your first notice will go to the general contractor. Your second notice that goes to the owner is going to go to the bond company. But again, you don't have lien rights, so we don't file a lien. You will, that second notice is going to be your claim with the insurance company, letting them know I'm owed money and this is my claim. We can always amend it if you continue to work and continue to have a balance. But if we miss it, we can't go back. So our collections, the GC usually has constitutional lien rights. So the prime contractor doesn't really have to send notices out. They're more automatically able to file a lien without having to notify everybody because everybody already knows they're there. Constitutional lien, because again, you're a direct contract with the owner of the property. You don't have to send your notices. You have the right to place a lien on any time as long as they continue to own the property. Subcontractors, you will have to follow the statutory guidelines. Job info sheets. I like to recommend our clients to have a job info sheet that gives you kind of the breakdown. This is the job site. This is a job name. This is the exact address. The GC's address and phone number. And if you can, also include the owner's information, because once you have to go do these notices, you already have the information there for you. Verifying information. This is kind of a little bit of research. The County Appraisal District will provide you some information on the property and the owner. Every county has an appraisal district, whether it's Harris County, Fort Bend, Brazoria, Montgomery, Bexar County, all of them have the CAD website. The CAD can tell you again if the property is residential, commercial, or public works. Just look at the classification on there and it's going to tell you what type of job it is. That again, classifications, residential, commercial. Other exempt government is where you know that it's going to be a public works job. Again, you don't have lien rights on public works. Verifying the general contractor information. So as long as you send notice to the registered address, it's a valid. If you're sending it to the job site and that's not the address for the general contractor, your lien could be invalid just by sending it to the wrong address. You can verify their addresses by one, the Secretary of State, or the Texas Comptroller also provides you addresses for companies, LLC, incorporated. So you can go on there and find their information, and that address would work as well. Texas Comptroller, this is their website, and you just put in the name and it'll come up as giving you their address and their information. Once you have your information, you're ready to release. Okay, examples on residential labor and materials supplied in January. So we're gonna go break it down a little bit simpler. So the first statutory notice is the intent to lien, sent to the owner, the general contractor, and your customer. It must be sent out by March 15th via certified mail return receipt. Remember, you have to include your invoices or a statement of the amount that you're owed. It does not matter if you supplied at the beginning of the month or at the end of the month, it falls into the same timeline. So that's one thing we get asked a lot. Oh, I didn't do work until, what was it, January 29th. Does it still fall under the same timeline? Yes, it does. From the 1st to the 31st of January. It doesn't matter where in between the month you did the work, it still falls under March. If you're owed for it. If you're not owed for it, don't worry about it. But if you're owed for anything done in January, your notice has got to be sent out by the 15th day of March. If you miss the intent notice or send the wrong address for any reason, do not file lien. It will be invalid. There is a $10,000 penalty for filing an invalid lien. So if I messed up the zip code, if I didn't include my statements, if I didn't include my invoices, if I sent the general contractor's name wrong, the owner's name wrong, if you did something wrong on that intent, your lien can be invalid. The liens should include the owner, the GC, your customer's information or your information, who your agreement's with, the legal description, when and what type of work did you do, the date you send out your notices. The lien has to be filed by the 15th in the real property records. Again, real property records is the county where you did the work at. So if my job was done in Harris County, I have to file my lien in the real property records of Harris County. Once you file that lien, a copy of the lien must be sent to the owner, GC, and customer within 5 days of filing. So 5 days of filing does not mean I have to wait for my lien to come back, because people do it still by mail. You don't have to wait for your file stamp copy to come back. You can mail a copy of the actual lien that you're filing to the owner, the general contractor. The notice must be sent certified mail, return receipts. Commercial notice to the general contractor and the customer must be sent by the 15th day, by March 15th. Via certified mail, return receipt. Remember to include your invoices and statements. It does not matter if you supplied at the beginning of the month or at the end of the month, it all falls under the same timeline. Second notice, intent to lien notice, owner, GC, and the customer must be sent out by the 15th of April via certified mail, return receipts. Remember to include your invoices and accounting statements. Again, if you miss the notice, don't file your lien, it can be invalid. There's a $10,000 penalty for filing an invalid lien. Lien must be filed by the 15th of May in the real property records where the project is located. This one, the same owner, general contractor, who your agreement was with, legal description, when and what type of work did you do, and the dates your notices were sent. A copy of the lien must be sent to the owner, the GC, and the customer within 5 days of filing your lien. It does not have to be the file stamp copy of your lien that you send them. Public Works, the first notice goes to the general contractor, must be sent by the 15th day of the month. Again, the second notice is the bond notice. This notice is sent to the owner, the general contractor, the insurance company, and the customer if you have one by the 15th of April. Certified mail, return receipt. This one includes an affidavit of sworn statement along with a copy of the payment bond. Payment bonds are very hard to get sometimes because they don't want to turn them over. So either one, when you're going to start a public works job and you know that it's already a public works job, get a copy of the bond in advance. The general contractor usually has them, or you can get them from the city. We're going to go into a little bit about waivers. So the state of Texas has provided 4 statutory waivers that should be used. The conditional on progress payment, conditional on final, unconditional on progress, unconditional on final. So the first one is conditional on progress. So this one is usually asked for when they're going to cut a check and they say, oh, I need a conditional waiver. I'm all for it. I usually hand these over right away as long as I'm going to get a check for it. Make sure it has a project, the name, who the check is coming from. Make sure you have the amount that you're owed. Who's it payable to? You can also include that it's, when is it paying you through? Is it paying you through April 31st, January 31st? You can put that little note in there so you know it's covering this time frame. Conditional on final. They'll ask you for this one, usually when you have already received the check. If you continue to do work, this is the one you want to give because you're not completely done yet, but the check that they paid you has already cleared. A conditional on final is okay. Just make sure you put in what time frame they're paying you through. Unconditional on progress means the progress payment you gave me has already cleared. I'm good. It's in my bank. Make sure it clears your account before you guys sign this one. Again, put what time frame they're paying you through. Unconditional on final. These you do not sign until you are completely done with the job and you have been paid and there is no balance due. There's a note on here that says, if you have not been paid, you do not have to sign this waiver. Do not sign this waiver unless they have paid you in full, because they can turn back and say, well, you signed the unconditional on final, therefore I have paid you everything I owe you at this point. And that can be a headache in its own. So a little bit more, if you didn't send your notices or you didn't have a timely lien, the next recourse you have is to file a lawsuit on a breach of contract. Our experience with that is those are very expensive. Litigation itself can be very expensive. We prefer our clients to protect their funds by filing liens. Guys, if you have any questions, please just let us know. We're here to help. We want to make sure that you guys understand the process and how it can protect you and how it does benefit in the end. All right. At this point, we're done. And Lee?
Yes, I'm here. Thank you so much, Jessica. Really appreciate it. So we're actually just going to open up the floor for any and all questions you may have. Please feel free to unmute yourself. You can ask Jessica directly, or you can send us a message in the chat. Okay. All right, thank you, Channing. We do have a question, Jessica. What are some good tips and tricks to track and ensure that you have everything correct in order to avoid filing an invalid lien?
You can always send it to us so I can look at it. It's just knowing your timelines, honestly. It's making sure that you're aware of the timelines that you're following. The GC statement, your first notice, is pretty simple, just letting them know I'm working for this person. I've been doing work from this time frame. Here are my invoices. You know, just making sure that they know you're there. The intent letter does have some statutory language that has to be involved, and we can always help you with that. But it's just knowing your timelines and making sure you know when you're filing your liens.
Okay, thank you. Okay, we have another question from Steve. How is a filed invalid claim removed?
So there's two ways. One, if they send you a letter saying your lien is invalid, please remove it. You can automatically just release it. Or they can file suit against you to remove your lien. Once they file suit is when they're entitled to that $10,000 penalty. But if you feel like you've done a lien that's invalid, again, please feel free to give us a call and we'll let you know if it is or not.
Thank you. Okay, we have a question from Thomas. If the window of notice times were missed, is there any recourse to file and or collect?
So if you missed it, it's more collections at that point. We start off by sending a demand letter, letting them know, here's what I'm owed, here's what I did. You have 30 days to pay me, or I can file suit against you on a breach of contract.
Okay, good. All right, we do have another question. If there are 60 days to pay retainages stated in the contract, when would you file the lien?
Okay, so retainage is a tricky one. Everybody always likes to talk about that one. There is, it depends on where you are in the job. So your pay applications usually have the contract amount, the amount you're requesting to be paid, minus retainage, and then what you're going to be paid for that billing cycle. At that time, you're already owed retainage. So you can, one, send out your notices, including your retainage. But a lot of general contractors are like, you're not entitled to it till 30 days after final completion. 30 days, guys. The owner has the right to pay out the general contractor 30 days after final completion. And when I say final completion, I mean everything is done. They are turning over keys. That walkthrough has happened. They are about to move into this building. That is what 30 days after that day. So if I'm taking over the space July 1st, everybody's lien has to be filed before or by August the 1st to have lien rights on retainage. 30 days after final completion. I always say 30 days after you're done. If I'm done in May and I haven't heard anything by June, I'm sending out my notices for that time, just to be on the safe side.
Thank you.
I hope that answered that question.
Great questions, everyone. These are awesome. Allison has a question. As a GC, how do I protect myself from a subcontractor that hasn't paid their supplier?
You ask for waivers from their suppliers. So when they're asking for that draw, you're willing to cut the check. Just say, of course, bring me the waiver from your supplier that they have been paid, and I will cut you your check. Or joint checks, a joint check agreement between them and their supplier.
Perfect. And Thomas has another question, and I'm gonna hop in and answer this. And Jessica, let me know if you would like to add any more. He's asking, he's interested in the cost to retain the firm and you to handle notices and lien filing. We did just roll out our a la carte mechanics lien services. You can pay as you go for notices and filing the lien. So that's anywhere between $200 and $620. We have our general retainer at $2,500. So if you're needing more than one thing, if you're wanting to have, lien services, but anything in additional, you have the whole team at your disposal, and maybe the best option for you. And then just the general mechanics lien packages includes all aspects from research to release. That's $1,070 to $1,200. Does that sound right, Jessica? Okay, good. And I'll follow up. I'll send everyone a follow-up email with the presentation, the handouts, and I'll also put our pricing. We have transparent pricing here at the Cromings Law Firm, so I'll definitely include that as well. Great question, Thomas. Megan has a question. As a subcontractor, what is your cost? So same thing to retain services. So, and then we have the contract states 60 days. Does it override the lien rights for retainage, or do we still follow the 30-day rule?
So you can put whatever you want in a contract, right? They're going to put whatever they want. That contract does not exclude your lien rights. So if it has 60 days, you still have to follow the statutory guidelines. So they're telling you 60 days, but the project is done way before that. If you didn't file your lien is gone. So just because the contract says 60 does not mean that you have to wait the 60 days, because statutorily we only have those 30 days. So yeah, it can override it at that point.
Mhm. Thank you. Perfect. Thanks for the great notes, everyone. Thanks for joining us. Do we have any other questions? Please feel free to unmute yourself or send more messages in the chat.
I think Steve said bonding subcontractors is another option to protect the GC. Yes, it is. It is. They can bond, or you can actually require your subcontractors to get a bond, and it will protect you.
Perfect. Yeah, we just had a great webinar last month on all of that too, which is great. Any other questions? All right, well, if we don't have any other questions, I just wanted to thank you all so much for joining us. We know that you're so busy during your work week, so it was really great to see everyone, and we will follow up with more information. I'm also, I recorded the session, so we'll be posting that on Facebook page, so I'll send the link to everyone in a follow-up email, so you'll be able to watch if you missed part of it or weren't able to tune in. So thank you all so much, and we hope you have a great day.